My please, sir. My lord, I beg to mention item number 12, my lord.
Yes.
This matter, my lord, may be adjourned for today, my lord. Due to my personal difficulty, my lord, I could not have prepared the case properly.
Mr. J.I. Borpia. Yes, MS Das,
Any day next week.
Learned Council for appearance has sought an adjournment on the ground of personal difficulty. Post of MS PIDAS, learned additional PIDAS, learned additional public prosecutor, who is in attendance, has no difficulty here. The praise allows the case, the appeal is passport for the case. Public.
My pleasure, Lordship.
Yeah.
I beg to item number 7, Lordship. Lordship, adjourn for the day, Lordship.
On the prayer of MS S.K. Nargis, learned counsel for the applicant. Comma, is passport for the day. Comma, as it is made with the consent of the learned additional public procedure for a one state of.
Lordship.
May I please, sir. Well, I'm praying for listing of a criminal appeal, my lord, which is pending from 2021 matter, my lord. And is last listed in June 2023.
Also before the registry,
It's a, my lord, convict under 302, my lord.
maybe there are many cases
Well, I'm praying for
Lining
last
up.
week. Last
lining
week.
up. If approach the registry.
My lord, may I please, your Lordship? I beg to mention one criminal appeal, my lord, division matter to be listed on 21st March for orders, my lord.
For what orders?
My lord, this is a matter for appellant is convicted, my lord, under section 302, my lord. And last year the case was admitted and thereafter the matter is not
First to
listed.
before the registry.
Must oblige.
May I please, my lord? I beg to mention item number 11 may kindly be adjourned for 1 week, my lord.
What is the ground?
Because the engaged advocate, Mr. A. Lal, is suffering from diabetes, suffering from dysentery, my lord.
You are Mr.
I am Pandit.
Mr. M. Pandit, learned counsel, appearing for Mr. A. Lal. Learned counsel for the appellant has submitted that Mr. Lal is in this post and has thus paid for the listing of the appeal after 2 weeks. Next, PLAS. Learned additional public prosecutor for the respondent number 1, State of Assam, and MS B. Sharma learned amicus jury for the lead. Respondent number 2 are present, and in view of the ground cited for adjournment, they have said, they have submitted that they have no objection to the safe prayer. The prayer is allowed, will the appeal after 2 weeks on a date 2 weeks by the office.
Much.
Any comment?
Not this.
Okay. This criminal appeal under section 374 within bracket 2 from our code of criminal procedure is directed against a judgment, an order dated 10/1/2024 passed by the Court of Learned Sessions Judge Guwahati in Sessions case number 136 within bracket S bracket close of 2016 by the judgment and order dated 10/1/2024, the accused appellants have been convicted for the offenses under section 302/34, Indian Penal Code. Full stop. The accused appellants have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 each, in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. In addition, the accused appellant number 1 has been convicted for the offense under section 323, IPC, and he has been sentenced to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for 15 days.
Yes.
Full stop. The appeal is admitted for hearing. Issue notice returnable in notice be issued returnable in 4 weeks. Full stop. As MS Das Learned, additional public prosecutor, has already entered appearance and accepted notice on behalf of the respondent state of Assam, the issuance of formal notice stands dispensed with. Extra copy. The yes records of sessions case number so and so be called for. I've just between notice. Extra copy within 3 working days. List the appeal after 4 weeks.
There's an application for bail also.
Therefore, suspension of sentence under section 389 CIPC will be considered on after receipt of the trial court reports. Much obliged. Records of the learned trial.
Statutory appeal against conviction, Lordship. This appeal may be admitted and record may be called.
So POCSO matter, Lordship.
What is the offense?
Section 4.
And the interlocutory application is to be considered after preparation of the paper book. List the yes after 3 weeks. For consideration of prayer. For suspension of sentence. With the paper book on record.
Okay.
Item number 5. My lord, here I am for the legal aid counsel on behalf of my lord, here I am for the legal aid counsel. I was supposed to be provided with a memo of appeal as per the last court's order. My lord, the same has not been provided to me.
Paper book is also not ready.
Yes, ma'am. My lord, let it come after 4 weeks, my lord. And in the meantime, paper book may also be prepared.
Same order,
Yes,
like the one.
yes, my lord.
T.H. Hazarika, learned counsel for the applicant appellant. MS S.H. Bora.
No.
Learned additional public prosecutor for the respondent number Assam, for the respondent number 1, state of Assam, and MS
S.G. Borua.
S.G. Borua, learned legal aid counsel
My lord.
for the respondent number 2.
My lord.
Full stop. According to the same office note. 72,024. Paper book not ready. After 4 weeks.
I will be taken after 4 weeks. Deeply obliged.
May it please the Lord. But appeal has already been admitted, my lord, and application for bail, my lord, suspension of sentence is before lordship, my lord. And
Notice
notice on
is not returned.
lordship.
Access to service to be served to. You have not served a copy to APP.
We have given my lord, copy in the office note, my lord,
Huh?
7-3, my lord. 7-3,
Extra steps for service of notice to be served to APP has not yet been received yet in connection. Have you seen the office note? When did you serve? Office note is of 7/3/2024.
lordship. Huh? Lordship, I will give.
Heard Mr. R. Ali, learned counsel for the applicant. And MS S.H. Bora, learned additional of the prosecutor for the respondent. Number, response state of sub, number one state of sub.
Not so.
The applicant was direct, comma by order dated 24/1/2024, comma. To take steps for service of notice upon the opposite party number 2. I go to the opposite party
Two.
number 1, scale of something.
Respondent number 2, Lordship.
To the learned additional public prosecutor for onward service. To the jurisdictional Borpeta Road Police Station. Poster. As per office note dated 7/3/2024, comma. Steps in deference to the said order have not been taken on behalf of the applicant. Poster. Mr. Ali Learned, counsel for the applicant has prayed for an opportunity of 3 days to complete the steps, to complete the necessary steps from his end within 3 days,
Lordship,
within 3 days.
Lordship.
Poster.
Lordship, first he has to send a scanned copy of the memo of appeal to the registry, then the registry will give us.
He'll do. You'll do
lordship.
3 days,
Yes, Lordship.
please the case after 4 weeks
Okay.
with the for service report
Obliged.
in respect of the opposite party number 2.
Lordship.
Item number 8,
Your Lordship, LCR received, but state has not filed their objection as on date. And service report
Notice
is,
issued, notice issued the
Notice
IA.
in Lordship, no, in the main case, Lordship, the informant also appeared. They
Not
filed,
IA.
their name is
Main
shown
case
in,
to some, main case to-
their name is shown in the cause list, Lordship.
Name not shown.
Name shown, but they have not appeared.
Okay.
I that this present interlocutor application has come up for first time.
Hearing. Otherwise, it is to be, it is fixed for hearing.
Lord.
LCR.
Paper book not prepared yet,
Paper book prepared now.
not prepared.
Pradeep Lakra,
Yes, paper book.
Oh,
is
yeah,
ready,
yes, I'm
Lordship.
sorry, Lordship.
This
Paper
one?
paper book prepared.
Yes.
paper book is ready.
LCR received the paper. book.
Though,
Let the matter-
objection.
We'll file the objection, but in the meantime, Lordship will fix it for hearing. Since paper book is ready and the answer has received.
This
If
is
it
matter of
goes for hearing, then it would mean that he is not pressing the eye.
Lordship.
Lordship, we'll
Right.
file objection, Lordship. Yes,
But we'll pass the order in eye.
Lordship.
Otherwise, if we pass in the order in the main appeal, it will go for hearing then as if he is not pressing the eye,
Yes, Lordship.
in the eye. Heard Mr. A. Ahmed. Learned counsel for the applicants. And MS. S.H. Bora. Learned counsel for the opposite party, dash respond number 1, comma, state of Assam. Post of none has appeared for the opposite party number 2, opposite party, dash respond number 2.
2 to 5.
So,
Lordship.
the name of the learned counsel is reflected in the call list. Learned counsel for the opposite party, that's respond number 2, is
Respond number
reflected in the call list. Full stop. The instant interlocutory application is for suspension of sentence under section 389 CRPC. Full stop. As the offense as the applicants appellants are undergoing sentence of rigorous imprisonment for life,
Lordship, right.
life under section 302/34, Indian Penal Code, MS Bora, learned additional public prosecutor, has sought for how much time?
4 weeks time,
4 weeks time,
2 weeks time.
3 weeks,
Lordship.
3 weeks time to file an objection to the instant interlocutory application. Full stop. The prayer is allowed. Please the case on. Twenty-two.
Obliged, Lordship.
Obliged.
Item number 9. May it please your lordship. This is an appeal along with an IA lordship against conviction passed by additional session judge Borpeta lordship
Under section,
under section 302, 323 and 325 for rigorous imprisonment for life lordship.
yes, Madam Bora,
Lordship will file objection to that.
as objection.
Lordship, there is an IA lordship for only 29 days because of
Lordship, this is an IF for condonation of.
condonation of delay.
So IF for bail is not moved.
We have not filed.
No, I am asking about the prayer for condemnation of.
Yes, Lordship. There is, I have no objection.
Main file.
Wait for it.
Hard MS and.
And
Shukri.
surgery.
Learned counsel for the applicant appellant
29 days.
29.
and MS SH Bora. Learned additional public prosecutor for the opposite party, that's respondent number 1. State of Assam. Full stop. The instant application is preferred by the instant application under section 5 of the Limitation Act 1963 is preferred by the applicant appellant seeking condonation of delay of 29 days, which has occurred in referring the connected appeal. Full stop. Yeah. The connected appeal, criminal appeal, which is yet to be numbered, registered, is preferred under section 374 within bracket 2 of the Code of Criminal Procedure 1973 against the judgment and order dated
28/11.
28.
against the judgment dated 28/11/2023 and an order dated 30/11/2023 passed by the Court of Learned Additional Sessions Judge within bracket FPC, Borpeta within bracket in sessions case number 211 of 2022 by the judgment and order, by the said judgment and order, comma, the appellant has been convicted for the charges under section 302, comma, section 325 and section 323 of the Indian
Yes,
Penal
sir.
Code.
Page 142 of the appeal memo, Lordship,
Uh,
order.
For the offense under section 302 IPC, the appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fines, to undergo simple imprisonment for another 6 months. For the offense under section 325, the appellant has been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. For the charge under section 323 IPC, the accused applicant appellant has been sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for a period of
3 months.
3 months. Full stop. No mention about concurrent. Yes.
It is mentioned, Lordship.
All the
All the
sentences
sentences.
will run concurrently
Where?
at page 2.
Hmm?
In the prayer portion.
No, the phase 2, no, where is the, in the judgment?
142 is the order. Lordship, 143 of the appeal memo, judgment, 143 of the appeal memo, the judgment,
Where is that? Concurrent
last paragraph, 11.
11. All the sentences are to run concurrently. Where are? It has been averred that due to poor financial condition, the delay of 29 of the applicant appellant, the delay of 29 days has occurred in preparing the accompanying appeal. It is submitted that there was no negligence or deliberate inaction or lack of bona fide on the part of the applicant appellant in causing the delay. MS Bora learned additional public prosecutor appearing for the respondent state of Assam, opposite party, that's number 1 state of Assam, has submitted that considering the sentence, conviction and sentence, the accompanying appeal is required to be hard on merits. Postman. Having considered the grounds mentioned for referring the appeal, connected appeal with 29 days of delay from a decision. Court is of the considered view that the applicant has shown sufficient cause for condoning the delay of 29 days. Accordingly, the instant interlocutory application is allowed to stop. The office to register the connected appeal and to list the same thereafter for admission.
Obliged lordship.
Feels very four.
Item number 13, some supplemented list.
Yeah, take it only.
না এইটো এক্সটেনশনৰ কাম মেডিকেল কাম
ফুল খানা আছে
না এইটো বৰপেটা
সেটা
Mr. Ali, see that prayer perhaps was granted because of precarious medical condition. That may not translate into a absolute order under
No.
389.
no
That prayer, it should be a limited one. But
Oh.
you are seeing that field disposal of the appeal.
this is an alternative my lord. For first prayer my lord, for extension my lord.
Because
His my lord, operation is going on today my lord from 8 a.m. my lord.
your prayer was granted only because you need medical treatment.
Lord. You need
And court has observed that it cannot be said that there is a fair chance of acquittal on the part of the applicant, though there could be a chance of acquittal. That has been observed. So, what is your alternative prayer?
alternative my lord, my lord period may be extended for my lord further my lord 3 months my lord, and his operation is going on today my lord.
I think the last time I got the medical report was way back, 2 months, 3 months back. So I may get a new medical report showing what
Okay.
exactly is the status.
But we may fix it, say, after 3 weeks, let him go. Undergo the surgery, but for the interim will extend. At
Till
least
his
you will have the
surgery.
opportunity to get the report
Yes.
after the
I'll
surgery.
get the report.
How he has recovered,
Yes.
how much time he will need to recover from the
Hmm.
post surgery.
Operation, yes. Today is the
I think-
last day
Huh?
of the interim order.
Tomorrow is the last.
Achha, tomorrow is the last.
Extend for the time.
Yeah, check it.
Wait. Okay, hard, Mr. R. Ali. Learned counsel for the
Report that,
applicant, no?
Report not again.
Appellant.
Report is answer.
And 14 paper. MS, SSH, yeah. Learned. Additional public prosecutor. For the opposite party, that's respond number 1. Postpone. The applicant is presently undergoing sentence. What is the order? Okay. Uh, has been convicted. Under section 6 of the Prevention of Children from Sexual Offences Act. And under section 376 within bracket AB. Is it true?
Lordship.
Whatever private party,
In 302, Lordship, notice was issued.
you prefer I also?
Oh, yes, I was disposed of. By the order dated 24/9/2019, I was directed to take steps through OC, Lordship, and accordingly I have taken steps.
So far as 302 is concerned, Lordship.
No, there is another order.
And 29/11/2019.
17,
29/11/2019 shows
there is IA 794.
Lordship.
Who is Jasminara Bibi?
Jasminara Bibi is PW8. She is the mother of the victim.
Oh,
Private
then
ones.
this order is there.
Yes.
Uh, we allow the applicant to participate in the appeal proceeding at the time of hearing. Subject to the condition 3021
Yes,
CRPC.
yes.
And limited to assisting the public prosecutor in charge and to give arguments with the permission of the court. The applicant is accordingly implemented as respondent number 3 to give her participatory right in the appeal. Ready to make necessary correction in the appeal. Appeal not corrected.
Lordship.
You want after Bihu. Mr. E. Ahmed, learned counsel for the appellant, has paid for listing of the appeal after 4 weeks in order to complete his instructions. MS S.H. Vora, learned additional public procedure for the respond number 1, state of Assam. This bill, which was, by an order dated 17/2/2023 passed in IA criminal 794/2020.
Yes.
Comma. The said interlocutory application for improvement of the applicant therein was allowed. And the applicant therein was accordingly directed to be implemented as respondent number 3 in the present appeal to give her participatory rights in the appeal, subject to the observations made therein. Post on perusal of the memo of appeal, It is notice that the response number 3. So the applicant in IA criminal 794/2022 has not yet been completed as the response number 3 in the present appeal. Full stop. Neither. Full stop. The has neither been named, nor the names of the learned counsel representing the applicant in IA criminal 794/2022 and the proposed response number 3 are reflected in the corpus. In view of the same, the raising to complete the applicant in IA criminal 794/2022 as party response number 3 in the present appeal. And to reflect the name of the learned counsel for the response number 3 in the respondent side in the cause list. Please the case appeal. 4 weeks. 32. Immediately after the ensuing vacation in April.
Obliged.
Number 14.
Perhaps yesterday they have finished their argument, I believe so. And may it please the lordship, I'll start. And in fact, the complicity of the appellants, all the 3 appellants, if your lordship is satisfied that yes, they were the aggressors, they were the perpetrators, then I need not go into that. Even my learned friend had said that the case is actually is of 304 part 1 or part 2, lordship will decide it today.
304.
Part 1 or part 2, that up to your lordship to decide. I'll place 3 judgments on that.
Yes, what is necessary for part 1?
Lordship, I will place 3 judgments. Lordship will just see. One judgment is very, of course, very long, and all judgments were referred and all. I'll place that also. I've sent all the judgments by email. Lordship can, I've taken it out from Supreme today. Uliasa ne? Uliasa? Okay. I didn't think that they had taken it out. The first judgment that I would like to refer is 2018 8 SCC 228. This is Deepak versus State of Uttar Pradesh. This is a short judgment. Their lordship will find, there the facts are like this. There was, the deceased was playing loud music. Appellant was objecting. Then he did not agree. Then appellant went back to his house, got a sword, and he gave a single blow on the deceased. And of course, the blow was on the rib cage area. Thereafter, the appellant ran away. And there was an altercation also before that, and which continued for 1 or 2 minutes. So in that case, it was converted to 304 part 2. Lordship will see there some deliberations were made. Paragraph 5, 6, and 7. Pages 2 to 8. It's also not another. There, lordship will find paragraph 5 facts I have already said. 5, 6, 7, lordship will go to that.
Yes.
I may read that relevant portion. Similar is the facts here also. Lordship will see paragraph 5. We have considered the submissions made respectively on behalf of the parties. The court has laid exaggerated emphasis and by erroneous application of the High Court. Yes. Lordship may go to paragraph 6 now. It is manifest from the evidence of the prosecution witness that the appellant and the deceased lived opposite each other across the road. Their houses were separated by a distance of approximately 25 feet. The genesis of the occurrence was the loud playing of a tape recorder in the house of the deceased, objected to by the appellant. A verbal argument ensued. The appellant rushed across to his house, came back with a sword and delivered a single blow to the deceased in the rib cage area and ran away threatening to see him later. The entire altercation is stated to have lasted for 1.5 to 2 minutes. On consideration of the entire evidence, can be safely be concluded that the occurrence took place in the heat of the moment and the assault was made without premeditation at the spur of the moment. The fact that the appellant may have rushed to his house across the road and returned with a sword is not sufficient to infer an intention to kill, both because the genesis of the occurrence and the single assault by appellant coupled with the duration of the entire episode for 1.5 to 2 minutes, had there been any intention to do away with the life of the deceased, nothing prevented the appellant from making a second assault to ensure his death rather than to have run away. The intention appears to have been to teach a lesson by venting the ire by irked a neighbor due to loud playing of the tape recorder. But in the nature of weapon use, the assault made in the ribcage area, knowledge that death was likely to ensue will have to be attributed to the appellant. In the entirety of the evidence, the facts and circumstances of the case we are unable to sustain the conviction under 302 and are satisfied it deserves to be altered to 304 part 2. It is ordered accordingly and so and so. Similar is the case, that is why I am placing this judgment here. Because it was also in the spur of the moment and intention perhaps was not there to kill, but knowledge will be there.
Knowledge is there and plus parietal region.
Yes. Here also ribcage
Knowledge
area.
is there. It is
Ah.
likely to,
Cause death.
but maybe because of, and it is also spur of the moment. It is
Ah.
not that there is no evidence that he had carried.
No,
Right.
that spade was
When
itself.
the FIR
Hmm.
plus evidence, there was conversation.
There was conversation. In order to avoid some untoward incident, he was going back to his house. Thereafter, this entire thing happened.
This is a natural thing that land dispute is always
Land
there.
dispute is there. And that weapon, that's a normal agricultural tool which every house will have. And the wife had handed it over to her husband. That is a small decision that I have placed. Next decision, Lordship will see. This is Anbaj Hagan versus State.
Huh?
Anbaj Hagan versus State. This Lordship will get.
Yes.
This is a citation. I don't have this. I have taken it from Supreme today. Anbaj Hagan versus.
We are from SSC.
Oh, Lordship has taken it from SSC. Acha. Anbaj Hagan, Lordship, the paragraph that I am relying upon is, of course, the paragraphs will not tell you, I believe. Paragraph 20.
20. Start
Paragraph-
the word.
Lordship, I'll just say. It's a long judgment. There it is defined what is
Maybe by
intention.
Justice Pardiwala,
Huh.
will be long judgment.
It will be long judgment. Intent and knowledge. The heading is intent and knowledge. Paragraph 20. Heading itself is intent and knowledge. That will be in bold letters.
Yes.
Lordship. Mine is here, paragraph 20. There perhaps paragraph Lordship. That is 20 only, Lordship. The word intent is derived from the word archery or aim. The act attempted to must be with the intention of killing a man. Intention, which is a state of mind, can never be precisely proved by direct evidence as a fact. It can only be deduced or inferred from other facts which are proved. Intention may be proved by res gesture, by acts or events previous or subsequent to the incident or occurrence on admission. Intention of a person cannot be proved by direct evidence, but it is to be deduced from facts and circumstances of a case. There are various relevant circumstances from which the intention can be gathered. Some relevant considerations are following. The nature of the weapon used, the place where the injuries were inflicted, the nature of the injuries caused, the opportunity available which the accused gets. These are the considerations. Then it's a long judgment, so I'm not troubling your lordship with so many paragraphs. Then paragraph 25, all are in fact relevant paragraphs, but it has tried to explain what is intent. Then lordship will go to paragraph 25. 23 also lordship will see Basdev case is referred. Here it is said in Basdev case, of course we have to distinguish between motive, intention and knowledge. Motive is something which prompts a man to form an intention, and knowledge is an awareness of the consequence of the act. In many cases, intention and knowledge merge with each other and mean the same thing, more or less, and the intention can be presumed from knowledge. The demarcating line between knowledge and intention is no doubt thin, but it is not difficult to perceive that they connote different things. Even in some English decisions, three ideas are used interchangeably, and this led to a certain amount of confusion. Then lordship will go to paragraph 25. Paragraph 25, did the lordship get?
Yes.
Yes. Bearing in mind the test suggested in the aforesaid decision, and also bearing in mind that our legislature has used two different terminologies, intent and knowledge, and separate punishments are provided for an act committed with an intent to cause bodily injury which is likely to cause death, and for an act committed with a knowledge that his act is likely to cause death without intent to cause such bodily injury as is likely to cause death, it would be proper to hold that intent and knowledge cannot be equated with each other. They connote different things. Sometimes if the consequence is so apparent, it may happen that from the knowledge intent may be presumed, but it will not mean that intent and knowledge are same. Knowledge will be any one of the circumstances to be taken into considerations while determining and inferring the requisite intent. Of course, they are different. There is no quarrel with the proposition. Then lordship will go to paragraph 28. This talks of knowledge. 28. This awareness is termed as knowledge. By the knowledge that specified consequences would result or could result by doing an act is not the same thing as the intention that such consequences should ensue. If an act is done by a man with the knowledge that certain consequences may follow or will follow, it does not necessarily mean that he intended such consequences and acted with such intention. Intention requires something more than a mere foresight of the consequences. It requires a purposeful doing of a thing to achieve a particular end. This we may make it clear by referring to two passages from leading textbooks of the subject, Kenny in his Outlines of Criminal Law. To intend is to have a mind is to have in mind a fixed purpose to reach a desired objective. The noun intention in the present connection is used to denote the state of mind of a man who not only foresees but also desires the possible consequences of his conduct. It will be noted that there cannot be intention unless there is also foresight. Since a man must decide to his own satisfaction and accordingly must foresee that to which his express purpose is directed, again, a man cannot intend to do a thing unless he desires to do it. This is from Kenny's book. And Russell, I'm skipping your lordship. The same things have been reiterated. Lordship will go to now paragraph 28. Lordship has already seen, yes. Then Lordship will, this is what intention and knowledge are being separated. Then Lordship will go to paragraph 46. Starts with Jagrup Singh's case. However, the learned counsel did not seek to rely on the observation. 46 subpara. Lordship will go to the subpara. We have noticed in the aforesaid observations.
Paragraph starts with what?
46 starts with, however, the learned senior counsel. No. Jagrup Singh's case, 81, Jagrup Singh case is referred in 45.
49 here.
Achha. So 49, Lordship will go to the subpara.
Yes,
We have noticed. Lordship got it?
there is no subpara.
Achha.
However,
49 consists of,
we have noticed that is paragraph 50 here.
Achha. We have noticed something in the aforesaid observations. We have noticed something in the aforesaid, the paragraphs that does not tell you, Justice Surana apprised us that since SCC has their own copyright, so they have the separate paragraphs and all other journals will have the same paragraph. That is why I think the paragraphs do not tally. We have noticed something in the aforesaid observations made by this court, which in our opinion creates some confusion. We have come across such observation in many other decisions of this court over and above the case of Jagrup Singh. What we are trying to highlight is that in Jagrup Singh's case, although this court altered the conviction from 302 to 304 part 2, it took shelter of exception 4 of 300. Why I'm placing this paragraph is, in fact, what Honorable Supreme Court said is while deciding conviction under part 1, then exception under 300 may be gone into. But while deciding and conviction under part 2, no exceptions is required under 300. That is what is reflected here. Although this court altered the conviction from section 302 to 304 part 2, it took shelter of exception 4 to 300. The question is, was there any need for the court to take recourse to exception 4 to 300 of the IPC for purpose of altering the conviction from 302 to part 2 of 304 of the IPC? We may so, because we say so, because there is a fine difference between two parts of section 304 of the IPC. Under the first part, the crime of murder is first established, and the accused is then given the benefit of one of the exceptions of 300. While under the second part, the crime of murder is never established at all, because that is culpable homicide, that is not murder at all. Therefore, for the purpose of holding an accused guilty of the offense punishable under second part of 304, the accused need not bring his case within one of the exceptions of 300.
What was exception 4?
Exception 4 is mutual fight, without any premeditation, without taking any cruel advantage. One is provocation, second is private defense, third is public servant, 4 is this one, mutual fight. You have to say something. No. I have to say something. নহয়, এইবিলাক দৰকাৰ নাই, এইটোতে কৈছে দেখোন। নহয় কি নতুন কৈছো। এইটোতে আছে কিন্তু rightly so এইটো মাথাতেই নহয় নালাগে পাঁচটোত গ'লে exception নালাগে 304 কৰিলেহে 304 পাঁচ ওৱানত যাব পাঁচটোত গ'লে 300 exception নালাগে it is not overruled it is not overruled entire session no entire session this is in fact a new thing that I'm learning because what we normally know is if it is culpable homicide not amounted to murder, then the case has to come in any one of the exceptions to bring the case under 304. But here it is, the Honorable Supreme Court has said not required in part 2.
What is the reason assigned?
Because that is not a murder at all. Lordship will see the subsequent part. In fact, the things will be clear if your Lordship goes to the beginning part, because there is a difference made between 299 and 300. And 300, all these things are taken, the exceptions. 200, Lordship, that section 299 and 300, it is explained from paragraph 33. The paragraph will again be different, but there is a heading
No,
299.
This view.
Huh.
So far, 299, 300 exception. Okay, now this view that when it is therefore no product of or there need to take for exception.
And this is a decision by the court. It's not a, there is no dissenting judgment. Lordship can see it from the first paragraph 33. Difference that was made between 299 and 300.
To arrive at this particular paragraph,
Huh.
he has traveled 50 paragraphs.
Just travel
So
so
we are sitting in a court to travel 50 paragraph is difficult.
difficult. That is why I have skipped
But
those. And
otherwise,
then after 46, Lordship will go to 59.
see 304,
Unbudged
the
Hagan.
body
Hmm.
itself say the heading itself says
Hmm.
punishment for culpable homicide not amounting to murder.
Hmm.
Both part 1 and part 2, both are culpable homicide not amounting to murder.
Hmm.
This is the first thing I have seen.
Hmm.
Otherwise, it is culpable homicide not amounting to murder. This is for punishing section. This is the
Hmm.
punishing section.
Hmm. It's a punishing, it's a charging section, yes.
And culpable homicide has been defined in 299.
Hmm. Yes. Whoever causes death by doing an act
With the knowledge that he is likely by such act to
huh,
cause that.
to cause
This is
death.
clear.
Hmm.
What more is required? Clarity is
Required,
required.
yes.
299 it is clear.
Hmm.
Whoever causes death by doing an act
With the intention of causing death.
or with the intention of
Intention.
causing such bodily injury as is likely to cause death,
Or
or with the knowledge that he is likely by such act to cause death.
death. Commits the
Commits the-
offense of culpable homicide.
So it is like say theft and theft in a dwelling house. Theft is theft. Theft in a dwelling house is an aggravated form of
Theft.
theft. It is culpable homicide. Then aggravated form of culpable homicide is murder, amounting to murder.
Yes.
It
Huh.
goes like this: culpable homicide, culpable homicide amounting to murder,
And not
culpable
amount.
homicide not amounting to murder.
So 300?
It is not like subject to murder. Then it comes down to culpable homicide.
No.
It goes from down to up. Culpable
the-
homicide, that is my
Hmm.
understanding. Maybe I may stand corrected with the judgment, but otherwise, culpable homicide is the genus.
There it is said. It is
Genus.
genus. Murder is just species.
Culpable homicide amounting to murder, and culpable homicide not amounting to murder.
Yes.
Right?
Hmm.
Then murder is defined, and
Yeah,
those are exceptions. Those are exceptions. 1, 2, 3, 4, 5.
And before going into the exceptions, Lordship may see 300, the explanations. These
Because otherwise,
Huh.
culpable homicide, let us once again read.
Mm.
What is there? Whoever causes death by doing an act with the intention of causing death, this is murder. Or with the intention of causing such bodily injury as is likely to cause death, this is also murder. Third one, with the knowledge that he is likely by such act to cause death,
cause
commits the offense of culpable homicide. I think this is
the genus. Yes.
the genus. Then it goes
It,
further.
it,
Let
it
us see
includes both.
300.
300, Lordship will see, except in the case hereinafter accepted, culpable homicide is murder. If the act by which the death is caused is done with the intention of causing death, here knowledge do not come.
That is first part of culpable homicide.
Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused.
That is
This is
second
also
part of
murder.
definition of culpable homicide.
This is
There are
also
three
murder.
parts of in a definition.
3 parts, yes.
Alternative part.
Thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary cause of death, nor nature to cause death. No ordinary course of nature.
So in all these three, there is intention.
Fourthly, there is none. If the person committing the act knows that it is so imminently danger that
Imminently
it
danger.
must, imminently danger, that it must in all probability cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury is aforesaid. This is, I think, knowledge.
No, but it has to be with imminently dangerous.
Imminently.
And it
knows.
must,
He
in
must
all probability,
cause death.
in all probability. Will
So
cause
these
death.
are all was firstly, secondly, thirdly, fourthly, these are all murder.
Then there are exceptions.
Then there are exceptions, 1, 2, 3, 4, 5.
One is
Provocation.
deprived of the power of self-control by grave and sudden provocation.
Second is self-defense. Then third is public servant, even offender is being a public servant.
If the right of private defense. Public servant,
4 is that sudden fight, mutual fight
sudden, right, without premeditation.
without premeditation. And fifth is this age of 18 years. Own consent. So it is said that perhaps this is the reason that intention, when there is intention, things get confused again.
See, let us, your Jagriti Devi,
No, look, before going to Rageti DB, I'll just point out
No,
two
no, let
paragraphs
us-
only.
let our fundamentals get cleared.
Jagriti Devi
You
Lordship,
see, say paragraph 29 of Jagriti Devi.
18, it's the
Let
paragraph.
us have a simple understanding.
Yes. Jagriti is paragraph.
Paragraph 29 referred to state of AP versus Raya Bharapu Punaya. There it says in simple thing, in the scheme of the penal code, culpable homicide is genus,
Yes.
murder is specie.
Huh.
All murder is culpable homicide, but not vice versa. Speaking generally, culpable homicide sense special characteristic of murder is culpable homicide.
Lordship is reading from section 299 and 300. No.
No. Your Jagriti Devi.
Jagriti Devi, paragraph 18, actually I'm
29,
relying.
it as referred to one judgment of state of AP versus Raya Bharapu.
Acha. In the case of AP. Before that, the earlier paragraph, section 299 and 300 deals with the definition of culpable homicide and murder respectively.
Yes.
299 defines culpable homicide as the act of causing death. 1. With the intention of causing death. 2. With the intention of causing such bodily injury as is likely to cause death. 3. With the knowledge that such act is likely to cause death. The bare reading of the section makes it crystal clear that the first and the second clause of the section refers to intention part.
Go slow, ma'am.
Yes. The bare reading of the section makes it crystal clear.
Hearing and understanding do not go together for me.
Yes. First and the second clause of the section refer to intention.
Paragraph 28 in simple term makes it clear. When and if there is intent and knowledge, then the same would be a case of section 304 part 1. Intention and knowledge.
Yes.
And if it is only a case of knowledge, and not the intention to cause murder and bodily injury, then the same would be a case of
Part 2.
section 304 part 2. That is the simple
Yes.
understanding. Knowledge and intent, part 1, and only knowledge with no intention will be part 2.
Yes.
Is it not? Now you come back to your Anbaz Hagan. Which paragraph you are referring to?
59 and 60.
Starts with
Lordship, I'll just give. Anbaz Hagan. '59 starts with, we may lastly refer to the decision of this court in Puli Cherla.
we may.
We may lastly. This is in the end of the little. Lordship got it?
Yes.
We may lastly refer to the decision of this court in Puli Cherla Nagaraju versus State of AP 2007-1, wherein this court enumerated some of the circumstances relevant to finding out whether there was any intention to cause death on the part of the accused. Quote, therefore, the court would proceed to decide the pivotal question of intention with care and caution, as that will decide whether the case falls under 302 or 304 part 1 or 304 part 2. Many petty or insignificant matters, plucking of a fruit, straying of a cattle, quarrel of children, utterance of a rude word, even an objectionable glance may lead to altercations and group clashes culminating in deaths. Usual motives like revenge, greed, jealousy, suspicion may be totally absent in such cases. There may be no intention. There may be no premeditation. In fact, there may not even be criminality. At the other end of the spectrum, there may be cases of murder where the accused attempts to avoid the penalty for murder by attempting to put forth a case that there was no intention to cause death. It is for the courts to decide that the cases of murder punishable under 302 are not converted to offences punishable under 304 Part 1 or Part 2, or cases of culpable homicide not amounting to murder are treated as murder punishable under 302. The intention to cause death can be gathered generally from a combination of a few or several of the following among other circumstances that I've already read before. Nature of weapon, whether the weapon was carried by the accused or was picked up from the spot, whether the blow is aimed at a vital part of the body, the amount of force employed in causing injury, whether the act was in course of sudden quarrel or sudden fight, or free for all fight, whether the incident occurs by chance, whether there was any premeditation, whether there was any prior enmity, or whether the deceased was a stranger, whether there was any grave and sudden provocation, and if so, the cause of such provocation, whether it was in the heat of passion, whether the person inflicting the injury has taken undue advantage and has acted in a cruel and unusual manner, whether the accused dealt a single blow or several blows. The above list of circumstances is of course not exhaustive, and there may be several other circumstances.
Now, there are many 12. There are 12 in next paragraph.
Huh.
Find out from these 12. Now, the author has given 12 more.
No, only 59 and 60 I'm relying.
No.
Acha.
The author
Huh.
in the next paragraph,
Next.
paragraph,
A few important.
have identified 12 more instances. Find out from that 12 anything fits into this case.
This is by summing up all he has taken out.
So find out from those
12.
12
Huh.
which one is nearer to the case in hand.
Case in hand. I'll get it. Doctor will come back. Question: what offense the accused could be said to have committed? The true test is to find out the intention or knowledge of the accused in doing the act. If the intention or knowledge was such as is described in clauses 1 to 4 of 300 of the IPC, the act will be murder, even though only a single injury was caused. To illustrate, A is bound hand and foot. B comes and placing his revolver against the head of A shoots A in his head, killing him instantaneously. Here there will be no difficulty in holding that the intention of B in shooting A was to kill him, though only single injury was caused. The case would therefore be of murder falling within clause 1 of section 300. Taking another instance, B sneaks into the bedroom of his enemy, A, while the latter is asleep on his bed. Taking aim at left chest of A, B forcibly plunges a sword in the left chest of A and runs away. A dies shortly thereafter. The injury to A was found to be sufficient in ordinary course of nature to cause death. There may be no difficulty in holding that B intentionally inflicted the particular injury found to be caused, and that the said injury was objectively sufficient in ordinary course of nature to cause death. This would bring the act of B within clause 3 of 300 and render him guilty of the offense of murder, although only single injury was caused. Even when the intention or knowledge of the accused may fall within clause 1 to 4 of 300, the act of accused which would otherwise be murder will be taken out of the purview of murder if the accused's case attracts any of the 5 exceptions that Lordship had said. In the event of the case falling within any of those exceptions, the offense would be culpable homicide not amounting to murder, falling within part 1 of 304. If the case of the accused is such as to fall within clause 1 to 3 of 300, it would be offense under part 2 of section 304 if the case is such as to fall within clause 4 of 300. Lordship, the Honorable Supreme Court has differentiated. Again, the intention or knowledge of the accused may be such that only second or third part of 299 of the IPC may be attracted, but not any of the clauses of 300 of IPC. In that situation also, offense would be culpable homicide not amounting to murder under 304. It would be an offense under part 1 if the case falls within second part of 299. While it would be offense under part 2 if the case falls within third part of 299. So what I can deduce from all this that everything depends on facts. Lordship has to see whether fact shows he had the knowledge or the fact shows he had the intention to.
What I said just
Ha,
earlier, that is summarized in paragraph 3.
ha, 3. Acha. To put it in other words, if the act of an accused falls within the first two clauses of cases of culpable homicide as described in section 299 of the IPC, it is punishable under first part of 304. If, however, it falls within the third clause, it is punishable under second part. And it's a subtle position. In effect, therefore, the first part of the section would apply when there is guilty intention, whereas the second part would apply when there is no such intention, but there is guilty knowledge.
Anything more?
Another question that had cropped up in my mind is section 34. Section 34 is again common intention. And if your lordship goes to part 2, then 34 will be difficult to bring in. But then I think that that question is answered by in this decision only by referring to section 34 as well. And it is said that it is permissible. 304 part 2 with the aid of 34 is also permissible.
Because see, the individual act,
Hmm.
so far the lady is concerned, she appeared to have handed over the
Hmm.
spade
Hmm.
to her husband.
Hmm.
That is one.
Hmm.
Secondly, who was the third one?
That Sabir, he had
Sabir.
the lathi.
Sabir.
Sabir Ahmed. He in fact came with a lathi and assaulted.
Say for PW 4.
Hmm. Yes. PW4, backside, from the backside he was
I
attacked.
saw Farooq Ahmed holding a spade.
Hmm.
Sabir Ahmed was holding a piece of wood.
Hmm.
What act was attributed to Sabir by PW 3?
PW3, he had also said they all the three assaulted. Lordship will see. I woke up, saw Joyna Farooq was Joyna, her wife of so and so, was handing over. After that, Farooq with that spade inflicted injury. At the same time, other accused persons, Sabir, assaulted my father with lathi. My father fell down, neighboring people came. Two had also said, I went to resist. Then Sabir Iqbal started to assault me. But here, assaulting the father.
What is answered in this page 30 regarding 34?
34. 34, it's there. That was a submission made that 34 could not be attracted, but Section 34 to 4 no, actually, there are two. Guys, judgment was made. Is 7 will keep by the page number 7. Because I think 7 by 5 feet or section 34. Read it section 34, right? No, you have to person.
Yes, Mr. Ahmed,
Not sure. No, I mean.
anything to add?
I will not take much time of your lordship, just I am relying on the judgment of Honorable Apex Court. It is reported in AR 2023 SC,
Yeah.
2023 SC 643. I'm sorry, I could not get that copy. Lordship, may I kindly see paragraph 2 of this case, facts of this case, which is squarely covers my case, okay? Paragraph 2, Lordship, may I kindly see. The state of Chhattisgarh hereafter the state prosecuted the appellants in relation to an incident leading to the death of one Brindavan. The prosecution's allegation was that appellant accused and Brindavan, the deceased, were cousins. On the afternoon of 28/2/2012, when the deceased was getting his land leveled through a JCB machine, the appellants reached the place and attacked him. Brindavan sustained several injuries, including head injuries. He was taken to the hospital and was examined by Dr. Bageshwar Patel. As serious head injuries were involved, Brindavan was operated by PW15. However, Brindavan could not survive and died on 22/3/2012. PW14 conducted postmortem and in his report stated that death was caused by injuries sustained by the deceased on the head. I'm pointing out here because Lordship, here also your Lordship may kindly see that date of incident is 28/2/2012 and the person died on 22/3/2012. And now just I'm taking your Lordship to paragraph 15. That already your Lordship has seen that section 299 and 300. And this paragraph 15, 15.
15.
15, 15.
Yes.
So what my understanding is that whenever their Lordship, there is a culpable homicide, Lordship, first that it has to decide whether it amounts to culpable homicide not amounting to murder or it is amounting to murder. And for that purpose, Lordship, there are certain exceptions in section 300. And those are, Lordship, clearly stated by Honorable Apex Court in Birsha Singh's case, Lordship. Those parameters are there. And what I find in the present case, there is no such exceptions exist to convert the present case to section 304 part one or part two, Lordship. Now just I'm taking your Lordship to just paragraph 22. Paragraph 22. And before reading paragraph 22, just I'm giving one fact before your Lordship that they said, Lordship, there was a cross case. And although there was a case lost by the accused side, that in that case, FR was submitted. And subsequently, they filed Naraji petition, protest petition, and on that basis, as a complaint case, it was tried before the same court and under section 323. And in that case, they were acquitted by the same trial court on the same date of judgment when they were convicted.
It was
It
there with you.
Yes, Lordship, that copy is with me, Lordship. So that's why I'm saying, Lordship, that there was no sudden quarrel, Lordship, for that purpose. And against that order, they have not filed any appeal till date.
Okay, paragraph 22.
Paragraph 22. The question is, was there a sudden quarrel between the deceased and the appellant so that the case would not be murder, but culpable homicide in terms of section 4, if it is committed without premeditation in a sudden fight, in the heat of passion upon a sudden quarrel, or without the offender having taken undue advantage or acted in a cruel or unusual manner. In the opinion of this court, there was no sudden quarrel. The testimonies of two important witnesses, PW1 and 2, here also in my case also PW1 and 2, established that when the deceased was leveling the septic tank on his property, the accused appellant started abusing him. He asked them not to. The appellants who were in the adjacent property climbed the wall, entered the deceased house, and attacked him with axes. These facts do not constitute a sudden quarrel, given that the appellants abused the deceased in an unprovoked manner, and then they went to where he was, armed with axes, and assaulted him. Arguendo, even if the facts are assumed to disclose that there was a sudden fight, it cannot be said that the accused failed to act in a cruel manner or did not take undue advantage. This is because they were armed, in fact, which shows premeditation on their part. Moreover, they both attacked Brindavan on the head, which is a vital part of the body, thus taking undue advantage of their situation. Paragraph 23. Again, on the question of whether the facts of this case are covered by first exception of to section 300, that is, that the accused appellants did what they were accused of, which is to attack and inflict grave injuries that led to the death of Brindavan because of their loss of self-control on account of a grave and sudden provocation. The answer must be the same, which is that the provision exception 1 to section 300 cannot be attracted. Apart from a long-standing pre-existing dispute, what caused sudden provocation to the appellants has not been shown by them. Neither did they lead any evidence to fall within exception 1, nor did the evidence on record substantiate such a contention. Speaking of what is grave and sudden provocation, this court in KM Nanavati versus State of Maharashtra explain the standard of reasonableness for applying the grave and sudden provocation in the following manner. Is there any standard of a reasonable man for the application of the doctrine of grave and sudden provocation? No abstract standard of reasonableness can be laid down. What a reasonable man will do in certain circumstances depends upon the customs, manners, way of life, traditional values, etc. In short, the cultural, social, and emotional background of the society to which an accused belongs. In our vast country, there are social groups ranging from the lowest to the highest state of civilization. It is neither possible nor desirable to lay down any standard with precision. It is for the court to decide in each case having regard to the relevant circumstances. It is not necessary in this case to ascertain whether a reasonable man placed in the position of the accused would have lost his self-control momentarily or even temporarily when his wife confessed to him of her illicit intimacy with another. For we are satisfied on the evidence that the accused regained his self-control and kill Ahuja deliberately. The Indian law relevant to the present inquiry may be stated thus. Number one, the test of grave and sudden provision is whether a reasonable man belonging to the same class of society as the accused placed in the situation in which the accused was placed would be so provoked as to lose his self-control. Number two, in India, words and gestures may also, under certain circumstances, cause grave and sudden provision to an accused as to bring his act within the first exception to Section 300 of the Indian Penal Code. 3. The mental background created by the previous act of the victim may be taken into consideration in ascertaining whether the subsequent act caused grave and sudden provocation for committing the offense. 4. The fatal blow should be clearly traced to the influence of passion arising from that provocation and not alter the passion had cooled down by lapse of time or otherwise giving room and scope for premeditation and calculation. Now 24, Lordship may kindly see paragraph 24. If one were to apply the above test to the present case, what is evident is that while there were pre-existing disputes of some vintage between the appellants and the deceased, there is nothing to show that they had been aggravated. It is also likewise not clear whether the deceased said anything to the appellants which triggered their ire, leading to loss of self-control as to result in grave and sudden provision. In any case, if there were something, the appellant ought to have brought the relevant material or evidence on record, as what the facts did exist was within their peculiar knowledge. 25. During the hearing, the appellant's counsel has urged that Vrindavan died 20 days after the attack, and the lapse of such a time shows that the injuries were not sufficient to cause death in the ordinary course of nature. On this aspect, there are several judgments which emphasize that such a lapse of time would not per se constitute a determinative factor as to diminish the offender's liability from the offense of murder to that of culpable homicide not amounting to murder. In Om Prakash versus State of Punjab, the death occurred 13 days after the attack. The accused was convicted of murder. Similarly, in Patel Hiralal Jaitaram versus State of Gujarat, the death occurred a fortnight after the attack. And in Sundaresh Kumar, the death occurred 12 days after the attack. Paragraph 26. There can be no stereotypical assumption or formula that where death occurs after a lapse of time, the injuries which might have caused the death, the offense is one of culpable homicide. Every case has its unique fact situation. However, what is important is the nature of injury and whether it is sufficient in the ordinary course to lead to death. The adequacy or otherwise of medical attention is not a relevant factor in this case because the doctor who conducted the postmortem clearly deposed that death was caused due to cardiorespiratory failure as a result of the injuries inflicted upon the deceased. Thus, the injuries and the death were closely and directly linked. In view of the above discussion, this court is the opinion there is no infirmity in the impugned judgment.
Here in the case, from the evidence of E.W. One,
Wow.
it is clear that the affair
Lordship.
was not lost instantaneously.
Lord.
It is after a gap.
Lordship.
When her father was undergoing treatment
Lord.
and after a day,
Lordship.
maybe more than after 24 hours.
Yep.
And her evidence is consistent with what she said in the affair. And from that, she had not deviated.
Right.
Then, from her evidence, it is clear that they were conversing.
Right.
Farooq Ahmed and the disease, her father was conversing about something land dispute.
Lord.
And the father said, let us decide on the dispute after the man comes back from Hajj. And thereafter he retreated to his house.
Lord.
Then after that incident happened. It is not that he had come armed like this Prasad Pradhan.
Lordship.
This is a slight distinction. FIR is lost after with clear mind. It is not that it has been lost instantaneously.
Right.
Just after the incident.
Right.
She had gone to the police station, returned. She came back, stayed in the house
yeah.
without doing anything for one day.
Right.
Then she lost the affair. So, without missing any important details,
Lordship.
it appears.
Right.
And her evidence as PW1 is consistent with the person in the affair, more or less.
Right.
And she also in her evidence did not depose that he came armed with, yes, maybe during the handed over the spade, but it is not a say instrument which is not readily available in a, I think it is a village area. It might be like somewhere.
Lord.
So yes, sir, I am not clear about this 34 aspect. You are saying something that
And even if the-
304 culpable homicide. 34 will not be affected.
No,
How?
I was mistaken. I stand corrected. That 34 parties answered in a division bench judgment in Allahabad High Court. I'll just give the judgment perfectly. There, the question was referred to a larger bench, and the larger bench answered that it is possible. 34 along with 304 part 2 can be done. I'll just say.
Whether then part 1 or part 2 will come, that your lordship may analyze, because here lordship, that part 1, so far my understanding is concerned, that part 1 comes only if there is intention, and part 2 will come if there is knowledge, lordship. And from the facts which here lordship, it appears that there was intention was there, lordship. That a vital part of the body that was hampered with lordship heavy weapon, that part is there. So intention was there. So it will come down to part 1 at least. lordship.
Okay, let us go through it. What I propose. Logically.
Okay. Yes, yes. Hmm. The first part, the intentions.
Mr. Najari, what you propose, these are so many evidence, what I propose. Let me go through all the judgments also. These are long judgments. Whatever is possible will, this, at least facts are to be reproduced. We keep it posted as part of tomorrow. We'll complete tomorrow. Whatever is facts are there, let us have the go. opportunity to go through whether it is 302, 304 part 1 or 304 part 2. If some doubt arises, we'll put the question to you.
Last page of that Allahabad High Court lordship can see. There it is said that that was a full bench decision. That question was written. And the answer was, we therefore answer the first question in the affirmative and hold that it is possible to convict an accused person under 304 part 2, read with 34. Penal code, provided the court is of the opinion that each person taking part in committing the crime in furtherance of common intention of all had knowledge that their act was likely to cause death. This is what is answer. This is otherwise 80 pages judgment, Lordship. I'll just this is the last page.
There are some issue is there whether if suppose it is 304 part 2,
Tough question.
whether common intention can be inferred or can be added to bring in, to rope in the other two issues.
No, in that case, Lordship, it will be get complicated for them, Lordship, because what my submission would be, if your Lordship takes up section 304 for a moment, Lordship, that explanation F 304 304, just not 304 Lordship, but 300 Lordship. I'm sorry, Lordship, just 300. 300 illustration F, Lordship, may I listen. The person who handed over those that is paid, he can be booked under section 300 for committing murder, Lordship, not under 304B, 304 part. Lordship, illustration F 300.
It's the right.
Now, what kind of, see, there is a difference between, say, common intention and common object. Now, whether it is not possible, say, in section 34. Generally, it is pre-oriented meeting of minds. But whether common intention can be formed in the course of the occurrence.
Yes, yes.
That is part of the moment it can be, because he has handed over that spare to the person who has solved it.
There is a very good judgment how to gauge common object. That is Godappa versus State of Karnataka. Work. I'll place it. I'm not getting it there. How to gauge their actions immediately before, at the time, and immediately after.
Yes, Mr. Chauhan, anything?
My lord, yes. My lord, if my lord, we go through the FIR, my lord, already your lordship read the wording. Then my father came out of the house and as he asked accused number 1 why he was assaulting us, the letter struck my father in the head with the hook that was lying on the courtyard. So he was alone at that point of time. The appellant number 1 was alone. Thereafter, the other question. Thereafter, that means, my lord, after that occurrence, my lord, hitting by a spade. Thereafter, member of the family from both the families, my lord, came. And if you lordship read together this PW2 cross, the spar of the moment. So, my lord, balance is to our side, my lord. PW2 and FIR. And FIR, my lord, in fresh memory, immediately, my lord, it was lodged.
Because all the witnesses are inside the same campus. It is
Yes.
not that their appearance at the scene is delayed. Everybody can appear at the scene without any delay.
Yes. And my
Right?
lord,
Near the pond, that pond is inside their entire campus. It is not that the son or the wife had to come from a long distance. They were there.
And even in their cross case, they admitted that mother, son, and the daughter was there.
thereafter, it is language is like this.
That is-
Thereafter.
Uh,
My lord, hitting was prior. And
that common intention can be formed during the course of the occurrence itself. There is
my lord,
no
at the
issue.
time of hitting by spade, the word is, my lord, FIR it is used thereafter. And if
You
my
were
lord-
on that axe and spade still.
no, spade.
You were
Mentioned in
on
the FIR.
spade and axe or what?
My lord, a spade mentioned in the FIR. I am on the I am on the spade.
On the FI,
And my lord,
fire says
cross of PW2 and this.
it's somewhere that he could not have it. That's his point.
So that is what I pointed out, that the informant had
Right,
no time to lodge the affair.
And my lord, this so many, my lord, things, my lord, adduced. But my lord, inquest report and postmortem, my lord, shows
Okay.
that, my lord, one, my lord,
Okay, let us go
Yeah.
through it. We'll propose tomorrow. If something is doubtful, we'll ask the council. Because so many things had happened because right from that putting a 161 statement.
Yes. Godappa Lordship can see how common intention has been formed.
No, it can be formed, this common intention can be formed during the course of the occurrence itself.
and my lord, the appellant
And-
number never came with arm, my lord. He was, my lord, just talking, the brother.
That has been,
So, my
what
lord,
has been
what happened,
falling
my
from
lord?
the code, it is not to be repeated.
So, my lord,
Mr.
they have.
Chauhan, what has already fallen from the code
Yes, my lord.
is not to be repeated.
Yes, my lord. So, my lord, intention,
Repetition and repetition will not
my lord, intention part, my lord. The part 1 say with
make the
intention.
sword double-edged.
Yes.
It will remain single-edged, single-sided. I have already indicated to you that this spade perhaps was not brought from inside the house.
No.
It is a regular agricultural
Yes, my lord.
tool which
Yes,
is
my lord, yes.
available in a
Every house, my lord.
rural house
Yes,
having agriculture
equipment.
as their activity. Perhaps it is available. So it can be picked up. It might be lying somewhere. It can be picked up. But question is 34. Whether that is to be attracted or not to be attracted. Let us go through again. We have time with the exercise. Any query is required regarding 34, 304, 1, 2, or 302. But I have to scan once more. Third, Mr. Vivin Ajari, senior counsel by S. Sohan, I'll be repeat for you. List the case tomorrow as partner.
That board up of paragraph 16 can be seen.
16 mark for you.
Paragraph 16.
Write it down
Yes.
in the judgment.
Ah.
I'll go to because not possible to go through all.
Only paragraph 16 is small paragraph.
So I mean tomorrow. Is this case specially assigned to this court?
Hard lordship. And in terms of lordship's order, they have filed the revenue authority have filed their affidavit lordship. We have received on 26 to 2024.
Okay, that deputy commissioner's record was earlier produced.
Yes.
Those three produced then. I think you have filed your affidavit.
Yes, but lordship, the affidavit is silent about our basic allegation lordship regarding the residential building lordship. It is lordship, if lordship peruse the page 62 of the date of affidavit lordship. It was for a specific purpose of Sangrohalaya, establishment of Sangrohalaya.
I think deputy commissioner's record, office records were produced earlier, right?
Yes, sir.
It was returned because of submission of counter affidavit by revenue department.
Yes.
Mr. Borbujari, who is supposed to get the records?
My lord, the government advocate, my lord. Now, here, my lord, the factual matrix, my lord, as on today lies. My lord, this one big plot of land, 1 bigha, my lord, that was the reserve. That was the reserve and it was settled in favor of Gandhi Sangrohalaya, my lord. And my lord, the premium was also, my lord, paid. Then, my lord, in that 1 bigha plot of land, there was an encroachment by the Gopinath Nagar Masjid Committee. And so, my lord, there were complaints, counter complaints from both the sides. In the writ petition, my lord, filed by Assam Gandhi Smarak Nidhi, there are allegations that the Masjid Committee has, my lord, made encroachment. And in their counter allegations, they have stated that in the land which ought to have been used for Gandhi Sangrohalaya has been used, my lord, has been given to a builder. The builder for development of, my lord, multi-story buildings. Now, my lord, whether those allegations and counter allegations, to what extent those have been meted out by the office of the deputy commissioner, district commissioner, that needs to be asserted. Because fact remains, my lord, that the land in question, part and parcel of the land measuring 1 bigha, it was due reserve. It was due reserve following due process of law.
That is what due process of law.
Yes.
What is due process of law? That was to be examined.
Yeah, no, my lord,
That court in 226 likes to examine.
yes, definitely, but that is not
That is
the,
what
yes. Now, my lord, the fact
court,
that,
I think on earlier occasion
Yeah.
thought it proper
Yeah.
to look into that aspect.
yes, and my lord, if my lord is perusing the affidavit filed by the revenue department,
I have seen
Yes, their lordship at page 62, that is the order.
nothing to be commented upon.
Then on the strength of that order, my lord, this
Because, okay, records were returned to Mr. C.S. Hazarika earlier for production of the same on the next date of listing. I think, yes, Mr. Dhar, sometime I remember that the petition society, it is society. Whether that man was alive.
yes, but by instruction, fair.
Because somewhere earlier, this chairman, because let me see, somewhere, someone was arguing.
Record produce করে Yes, Mr. Karunakanta Barua.
Someone was arguing. There, who's the affidavit? 4 and 5. It is said that that man died. That man died in their affidavit. Yes. I kept it pencil.
He was the chairman of the society.
Died 4 years back. That was an affidavit, I think, sworn on 22nd February 2021. Paragraph 5. Do you have the copy? Do you have the affidavit, Mr.
Yes, Lordship.
Kolita?
It has come to knowledge and information of the
So-
deponent recently that
Mr. Dhar, see that apartment. Sub paragraph. Who is the state council? Mr. Hazarika. You earlier produced that.
Earlier, yes, I will.
Yes. Get the records there. Because on 28/4/2022, it is reflected that you produced the record. Then on 36/2022, records produced by Mr. C.S. Hazarika, Lane Junior Government Advocate Assam, is returned for production was same on the next date of listing of the case, and occasion never arose in later point of time. So you get the records. That will do. You in down and verify. Whatever.
At that note, when the liquidation was filed, he was the chairman, in which capacity is the chairman of the society, he told that. But presently, it's not. I am getting.
Aid her. Item 1. A Kolita. Item 2. R. Borpuzari, standing also Revenue Department. And Mr. C.S. Hazarika, Learned Junior Government Advocate for the other state customer. Mr. Hazarika, Learned Junior Government Advocate Assam, shall produce the records of the de-reservation proceedings undertaken in respect to the plot in question on the next date of listing. April, maybe after review.
At the time of filing this affidavit, I had summoned, my lord, the officers of the department. Some old officers of the department had also come because they were aware about these facts. Retired officers of the record, my lord, they told me that this person, my lord, Karuna Kanta Barua, he was a devout Gandhian and a man of impeccable integrity. That is what, my lord, they told me. Thereafter, my lord, things have changed perhaps.
But that situation appears to have been diluted by the private respondent.
Yes, because since the, now the facts are.
Impeccable
Yes,
integrities.
since facts
They have
are.
casted doubt
Yes,
about impeccable integrity. At least by indicating to some registered deed.
facts are disturbing now. This is the difference.
22, April.
20.
This is the case on 22, 2020. Because
So,
this court will not be sitting for 2 weeks.
I don't know what to read.
In this matter, we have received the instruction, Lordship. Proposal has already been sent, Lordship, on 13/12/2023, Lordship.
13/12/2023. Yes,
No,
Mr.
my inspection is that they have not received the proposal.
Basically, it is the inter-departmental things which have to be sorted out.
Supernumerary for creation of supernumerary force. That has to come, and they have said that it is, a reminder has been given to them on 6th of February. But they have not received. I'll give a copy to my friend, Malad. Let him at least.
Last line, Lordship. After receiving the same, the Honorable Guwahati High Court filed its modified order communicated under memo number so and so, dated 7/12/2023, asked this office to forward the proposal letter. Accordingly, the same was sent to the Honorable District and Session Judge Bongaigaon, filed memo number so and so, dated 13/12/2023, Lordship.
Why didn't you exchange your?
Yes, that, but in fact, my communication says that they have sent a proposal to us. We have placed it before the finance. Finance has raised some objection. We said that along with the checklist they have to give. So may I just read that? In inviting a reference to your letter on the subject, I am to direct that to inform you that as per our record, Judicial Department received a proposal on 31/10/23 from the Civil Judge Junior Division North Salmara, Voyapuri, for creation of supernumerary post of copies. The said proposal was taken up with Finance Department for concurrence. In response, the Finance Department advised us to resubmit the proposal along with a duly authorized checklist. Accordingly, this department, by letter dated 12/1/24, requested the Civil Judge Junior Division North Salmara, Voyapuri for the needful, followed by our subsequent letter dated 6/2/2024, addressed to the District and Session Judge Bongaigaon with a copy to the Civil Judge Junior Division North Salmara, Voyapuri. However, response from the Civil Judge Junior Division North Salmara are still awaited.
Read the other one.
Lordship.
In compliance of the order.
Order dated
19/9/2000.
19/9/22 passed by the Honorable High Court.
And its subsequent letter dated 6/10/2023 passed in IA. A proposal letter for creation of supernumerary post of copies with retrospective effect in the office of the civil judge was sent to the legal remembrance secretary judicial
Hmm.
by memo number so and so dated 30/10/2023. Right?
31/10/23.
Now take your letter.
Yes, 31/10/23 we have received.
Then that was received.
Yes,
That was sent back
that was
by the
sent.
finance bank department.
Lordship.
Read the letter again now.
After receiving the
After
same,
receiving the same, the Honorable High Court by modified order dated 7/12/2023 asked this office to forward the proposal letter to the Honorable so and so. And accordingly, the same was sent to the Honorable District and Session Judge by memo number dated 13/12/2020.
Hmm.
So that he admitted 31/10/2023.
yes, both sides.
Thereafter, that proposal was considered returned back by
Yeah.
your letter
Yes, yes.
indicates that.
Lordship.
But again, on 13/12/2023,
Hmm.
civil judge had sent another proposal.
Through the,
What consideration was given to that proposal? See, 31/10/2023.
it is admitted. It is admitted from both sides. Lordship.
So you find out the
Yes,
status
yes.
as regards this proposal sent by the civil judge
Yes, yes.
on 13/12/2023.
Yes, yes. Lordship.
If it against has entailed a rejection, then we have to proceed further.
Yes, yes, Lordship. Malad, in fact, they are awaiting the proposal with the checklist suggested by the finance.
It seems that on 13/12, there is another
They have said. Lordship.
Heard, Mr. There is no representation on behalf of the petitioner today on call.
In fact, he called me in the morning, Malad. He was supposed to inform me when the Honorable Court says for this item.
First of all, Mr. Dinath Lanak, Senior Government Advocate Assam for the response number 1. And Mr. N.K. Sharma, Lanak Counsel representing Mr. H.K. Das, Lanak Standing Counsel, Guwahati High Court, GHC for the response number
4, 5, 6,
4,
and 7.
5, 6, and 7. Full stop. From the communication bearing number so and so dated 12 March of the civil judge, Junior Division, North Salmara, Abhayapur, dated 12 March 2024. And the communication placed by Mr. Sharma and the communication bearing number so and so dated 12 March 2024 of the Judicial Department, comma, it transpires that after return of the proposal dated 31/10/2023 for creation of a supernumerary post of copyist, comma, another proposal from the Office of the Civil Judge, Junior Division, North Salmara, Abhayapuri, was sent with memo number so and so. Memo number, it's I have considered, yes, dated 13/12/2023 to the Office of the District and Session Judge, Bongaigaon, to the Judicial Department. Full stop. The Learned Counsel for the respondents have submitted that they would obtain a status report as regards the proposal dated 13/12/2023 and shall apprise this court thereafter. Post of they have sought for listing of the case after 2 weeks. List the case review appeal of Bihuragat. 8 of April.
8/4, no, sir.
I would learn a concept, but there is some communication going on and on.
But I am not sure whether during my lifetime I will be able, because now I am bedridden, man, unable to.
Get it expedited.
Lordship. I'll take it up, madam.
I am.
Problem.